submission in the matter of the Commissioners for His Majesty's Revenue and Customs and Hotel La Tour Ltd.
Yes, Mr. McArdle. Do sit down. We understand that you broke your foot.
Thank you.
Prefer to address us seated. Do you please do so?
That's greatly appreciated. I hope to get through the day without needing to do that. Thank you. Good morning, my lord, my ladies. I'm the Revenue, and my learned friend Mr. Firth appears for Hotel La Tour Ltd, the taxpayer company, in this appeal. There is very little in the way of housekeeping. The court should have received a core bundle coming to 162 pages.
Yes.
Supplementary bundle coming to 102 pages.
Yes.
And an authorities bundle at 566 pages. If examined in hard copy, there will be 2 files with tabs 1 to 22 in the first of the authorities bundle files.
Yes, thank you.
There is an application as part of this appeal in order for HMRC to apply to rely upon a new argument.
Yes.
I'm, of course, in the court's hands, but my intention is to address that later on in my submissions when it naturally would arise, because it is a response to an argument in the respondent's notice.
Yes.
Otherwise,
have you discussed with Mr. Firth how we've got a day and a half, how the time is to be divided up?
we have. My intention is to try to speak finishing at about 3 o'clock today.
Yes.
It being understood that I may have to cover some more ground, as it's my appeal, and facts of cases, for example, I will need to cover to a greater extent, which should leave Mr. Firth with enough time to make his submissions, perhaps leaving me half an hour to 45 minutes tomorrow in reply shortly before lunch.
That sounds perfect, thank you.
So,
yes.
In outline, perhaps unsurprisingly, the order of my submissions will be very briefly to give a summary of HMRC's position and what we say fundamentally went wrong in the tribunals in this case. Secondly, to address what the tribunals actually found briefly. Thirdly, I will spend most of my time on the case law,
yes,
dealing with direct and immediate link, both in relation to specific supplies and overheads. And fourthly, I will address the respondent's notice grouping argument.
Yes.
And I have 2 points to make on that. In relation to our first argument, that is an old argument, as it were, which has been raised before.
And then you've got a new argument.
Exactly.
Yes.
So, in essence, this appeal concerns the question of whether the use of inputs in value-added tax in a specific supply for consideration in the course of economic activity means that recoverability of that input tax turns on whether that supply is taxable versus exempt, in which case it will not be recoverable. That is HMRC's position. Or whether such use in a specific supply can be looked through or perhaps ignored, where some or all of the consideration paid for that supply is objectively intended to be used in downstream business activity of the supplier, such that whether that input tax can be recovered turns on whether that downstream activity is taxable or not.
Yes.
Now, as you will have seen from my skeleton, I won't labour it, but the appellants contend that there is a need in a case like this, where there is the potential for inputs to be directly and immediately linked to a specific exempt supply versus general business activity, to perform a 2-stage test to ask, is there a direct and immediate link, applying the ordinary long-established test to the specific supply, and if not, and only if there is no such link, then the question arises as to whether there's a direct and immediate link to downstream business supplies, such that the inputs, the overheads, and therefore, if those downstream supplies are taxable, then the input tax can be recovered in relation to those overheads. Now, I will go on to take the court to the specific paragraphs at least briefly, but the 2 tribunals did find correctly that there is this need to engage in a 2-stage process, looking first at the specific supply and secondly at the general business or downstream business activity. But the circumstances where the tribunals found that use in the specific supply will determine the recoverability, and in an exempt supply will mean that there is no recoverability of the input tax, where we say impermissibly narrow and contrary to authority. Because broadly, what the tribunals find, and it's fair to say they're not entirely consistent with this point, but broadly they find that unless the consideration for the specific supply, so the price of that specific supply, has been adjusted or includes apportionment for the cost of the inputs, then there is no direct and immediate link to it such that it governs whether or not the input tax is recoverable. What we say has changed through the case law from BLP in the 1990s to now is that in relation to overheads, that is in a case where there are inputs and the argument is, are they linked not to any specific supply, by definition as overheads, but are used in general business activity, then the courts and the tribunals are permitted to look at what the objectively construed overall purpose is of those inputs.
And is that what you say the BLP amendment is? So it's because BLP, the famous passage, talks about not looking at the purpose to which particular inputs are put. Is that the bit then that you say has changed by Kretz technique in other cases?
My lady, exactly.
It's the purpose
Yes.
test in BLP that's been washed through or washed down or washed out.
Correct. So in relation to overheads, there isn't a profound change in the direct immediate link test, but it is now permissible for the tribunals or courts to look at the objectively construed purpose, as is discussed in, I think, the penultimate paragraph of Franke Smart in the Supreme Court, which I will come to in a short while.
But you say you don't get there if at stage one there's a direct and immediate link to an exempt supply.
Precisely, my lord, yes.
Yes.
Can I just backtrack a little bit? This is helpful to have your overview. But what you mentioned just now was the acceptance of the tribunals that you engage in a two-stage process.
Yes.
But you say that the tribunals went wrong in being impermissibly narrow and contrary to authority in where supplies fell out under stage one. Is it your case that I understood that maybe you were saying that they had altered the direct and immediate link test in some way to look at sort of costs or adjustments or apportionments of cost, and in other words, they stepped away from what you'd earlier described as the well-established path. That's
Exactly.
part of your case. So
My lady, exactly.
is that, well, you'll come to it, but
Yes.
that's the error, or yes?
It is, but a slight complication, and perhaps this is my misreading and I'll be corrected, but my understanding of what Mr. Firth is saying, although on the one hand he says in his skeleton that he supports the reasoning of the tribunals, but in paragraph 95 of his skeleton, I don't intend to turn to it, but for your reference, it's core bundle tab 4, 75. He says the specific modification made by the CJU at paragraph 68 of SKF was precisely to treat the costs relating to the exempt disposal of shares as part of the taxable person's general costs. Now, it is of course for him to explain what he means by that, but he may be suggesting there that there is no set of circumstances where use, direct and immediate link with the exempt initial transaction prevents recovery, provided that the objective purpose of incurring the inputs is downstream taxable business activity, which is not what the tribunals say. They do.
Sorry, can you unpack that for me? I haven't caught up with you. So, 95 of his skeleton, he talks about what he says the modification is. Can you just
So, again, it may be I'm misunderstanding what he's saying, and he will unpack it differently. But I understand him to be saying in his skeleton, especially paragraph 95, that there is no use, there is no direct and immediate link which the exempt share sale can have, which will prevent a finding, provided that the objective purpose is there of use in downstream taxable activity, which will prevent the direct and immediate link that matters for recovery arising in relation to the downstream taxable activity.
in other words, I mean, I picked that up from his skeleton as well, that he says it's automatic.
Yes.
In other words, that if you have this sort of case,
Yes.
it is automatic and axiomatic that you disregard,
Yes.
don't take account of, you don't think about the exempt supply of
Yes.
shares, you go straight to overheads.
Yes.
Is where we are.
That is my understanding of his submissions, both in his skeleton and at the tribunals below. But of course, he may take a different point. I don't want to preempt what he's going to say, but I simply highlight that because that is not what the tribunals actually did. We say they went wrong, but they didn't go as wrong as that. So, in relation to factual background, I will be very quick because it was never disputed, as I'm sure the court has gathered. Hotel La Tour, the respondent, was a representative member of the VAT group and owner of the shares in question in a company called Hotel La Tour Birmingham. And that company was operating a hotel in Birmingham. Management services were being provided by the respondent, Hotel La Tour, to Hotel La Tour Birmingham in relation to that hotel operation. In order to build a new hotel, so in order to carry out taxable economic activity, Hotel La Tour planned to build a new hotel in Milton Keynes and operate it. And in order to do that, among other activities to raise funds, it planned to sell the shares in its subsidiary and VAT group member, Hotel La Tour Birmingham. And to perform that share sale, there were various inputs incurred. The ones in issue include market research, buyer shortlisting, financial modelling, and tax compliance. All of them were, as described in the respondent's evidence, with a view to obtaining the highest sales price for shares available. So I just pause there to say that they are all inputs which, on any sensible view of the ordinary direct and immediate link test, are used in directly and immediately linked to that exempt share sale. The proceeds were used in part to build the hotel in Milton Keynes and also to pay off a loan of the subsidiary Hotel La Tour Birmingham, as well as to pay for the inputs such as the buyer shortlisting. So the inputs which we are considering, the inputs of relevance here. And Hotel La Tour sought recovery of the input tax. That was refused on the basis that the direct and immediate link lay with the exempt share sale, not with the general business activity, which was the taxable supplies of operating hotels.
Can I just, you said that the proceeds of sale were used for the new hotel in Milton Keynes and to pay
Yes.
the inputs. Is that a factual finding? I mean, does it matter? Where's the factual finding?
It is. There is a factual finding, if I can take a moment. It's also in the undisputed evidence of the appellant, so perhaps I could give that reference first.
Yep.
Mark Stewart was the witness who was the managing director of the respondent, and in the supplementary bundle, tab 2, page 102, especially at and around paragraph 11, he describes the various inputs and how they were all purchased for the purpose of the shares, to the sale of the shares.
That's not quite the same question.
Sorry, my lord, perhaps I misunderstood the question.
What you said, what I wrote down was the proceeds of sale were used to pay the costs.
Yes.
Well, I took that to be a cash flow question, an actual accounting question, that you don't pay your solicitor's bill until you've got the proceeds of sale, and then you pay them out of the proceeds of sale. And I just wondered if that was a factual finding.
That is a factual finding, and I believe that's also on the same page of the evidence as well.
Right.
Yes. The inputs were paid out of the proceeds of the share sale.
That's para 14, is it, after paying off the existing loan and costs of sales? That's what
Correct,
that's
yes.
saying.
That was unchallenged evidence, and it does make its way into the FTT's findings.
Can you show us where it's in the
Yes.
FTT? Thank
I
you.
apologise, I don't have the paragraph immediately to hand, but I will find that in a moment. So it begins at page 119 of the court bundle. At page 121,
I think it's paragraph 9 is what you want,
Paragraph
isn't it?
9, yes. This comprised the consideration for the purchase of the shares and the repayment of HLT's loan to HLTB, less the costs of sale, including the fees for the professional services. And that is critical to the analysis which the tribunals perform.
Thank you.
So if we could begin then in the same bundle and in fact in the same tab, and so we could pick up at page 130.
Are we going to an analysis of the FTT?
Exactly, yes. So this is the first tier tribunal decision, and this is where we say it goes wrong. In the court's own time, I would invite reading certainly paragraphs 36 down to 44, if I may pick out from those paragraphs certain key points. At the bottom of page 30, paragraph 36, we see there the tribunal accepting the first line that the first stage of the analysis is to be modified in fundraising cases, in the sense that with one rider, the initial share transaction is to be disregarded. So we say that that's wrong, for reasons I'll come on to, but that is the acceptance of the tribunal that there is a special modification just for fundraising, but that one rider is, I will come on to, where it says that you cannot disregard the use in the initial exempt sale. It then quotes various passages from Frank Smart, including paragraph 47, which I will talk about later, but 47 is important because it does explain the test to be applied in a case like ours, which is a two-stage one. And that there is the need to analyse whether the exempt initial
Sorry,
transaction...
I've lost my place. My fault. Where am I? I was at 36. Where should I go next?
Over the page at...
Internal 47.
Internal page, paragraph 47. Which is quoting part of Frank Smart, which I will deal with when I come to that case. But essentially, what is said there is, we've seen reasoning outlined above, and then an explanation of the need to consider whether we are addressing an exempt downstream transaction or an initial transaction. 38, the tribunal concludes that Lord Hodge treated the CJU as extending the treatment of share disposals outside the scope of that to those where the share disposals are exempt. As such, the relevant consideration in fundraising cases, here's the tribunal saying fundraising is a special category, whether the services are incorporated into the price of the initial share transaction. I think there should be an or in that, or in the downstream transactions. And we see, again, a quotation, an internal paragraph 49 from Frank Smart, which, in fact, helpfully includes, again, our case, essentially the need to perform this two-stage test. 3 lines down, on the contrary, in order to avoid discriminatory treatment of taxable persons, it, CJU, has extended the reasoning in cases about share disposals that are outside the scope of VAT to share disposals which are exempt. But how is the important question? By requiring an examination as to whether the costs associated with the input are incorporated in the price of shares in the initial transaction, or in the prices of the taxable person's products in downstream transactions. So that is, again, saying there is the need to perform this analysis. We don't simply ignore use in an exempt transaction. At 40, we see a critical recognition here. We agree with Ms McArdle that in general the necessary direct link exists if the services are part of the cost components of the taxable person's transactions which use those goods and services, and that this has a chain-breaking effect. The passage then goes on to say, but there's a special regime essentially for fundraising. And it quotes parts of Frank Smart in support of that. pausing here, we say that Franke Smart is entirely consistent with our case, but as it is a decision concerned not with an initial exempt transaction, but with transaction that isn't a supply at all, it doesn't say a huge amount about treatment of exempt transactions. 41, it follows that we agree with Ms McArdle's submission that an objective assessment of the purpose of the fundraising is required, as distinct from subjective intentions of HMRC. We also agree that the chain will be broken if the costs of the services are a cost component of fundraising. However, for the reasons set out above, we do not accept that the use of the services of the fundraising transaction prevents deduction. So again, we see an acknowledgement there from the tribunal that there are some circumstances where a direct and immediate link will be found in relation to the initial fundraising transaction, which is exempt. But confusingly, and we say wrongly, that use of the services in that transaction is not sufficient to amount to the necessary direct link. We see analysis at 43 and 44 of the facts of the case, including some important factual findings which are not disputed. For example, about 4 lines from the end of 43, objectively analysed, the services were only necessary to facilitate the sale itself. Indeed, Ms McArdle rightly makes the point that the services were purchased and sold at professional fees incurred in order to maximise the selling price. 44, Ms McArdle also makes the valid point that the services were all part of the process of selling the shares. But at 46, we see the critical reasoning as to why the tribunal in this case found that there was no direct and immediate link such that the exempt share sale caused the non-recovery of the input. I would, of course, invite the court to read that at its own time, but it's important to understand the narrow way in which the direct and immediate link test was understood here. We find that the cost of the services were not incorporated into the price of the shares sold in and were not cost components of the price of the shares in the initial transaction. Now, incorporated in the price, cost components, we say are synonyms for the ordinary direct and immediate link test, and that none of the authorities say that there is a different test in a fundraising transaction or any transaction where there is a question of whether we're dealing with specific supply using inputs versus them being overheads used only in general business activity. The reasons are, the agreed evidence is that the shares were sold for the best price achievable in the market. Price was not increased in order to provide for the costs of the services, and there was no allocation for such costs within the price. Now, the tribunal does go on to say, we note in this regard, that although there is no requirement for such increased price or allocation in order for the cost to be components of the price of the shares, the presence of such increase or allocation would support the cost of the services being cost components of the initial transaction. We say that's wrong, it's an overly narrow test, and it is recognised by the tribunal that that is not definitive, but it still seems to have placed very significant weight on it, because the only other reasons given for no finding of direct and immediate link to the exempt share sale are, at the end of the paragraph, instead the services were paid for out of the proceeds of sale, thus reducing the amount available for the taxable transactions, and so being a cost of those taxable transactions. We say that is no part of the conventional test. In fact, there is recent CJ authority in terms saying that the source of the funds to pay for the inputs, to pay that consideration, does not determine where the direct and immediate link lies. And further, for the reasons set out above, the objective purpose of incurring the costs of the services was in order to raise the funds to pay for the downstream transactions. And again, we say that's all very well if you've got to the stage of rejecting a direct and immediate link with the specific exempt transaction, but that forms no part of the finding of whether or not that exempt transaction is directly and immediately linked to the inputs. It's a stage 2, not a stage 1 part of the analysis. So we're left with lack of price increase our allocation for the shares to cover the costs of the services, although they were, as a matter of fact, paid out of it. And the fact that they were paid out of the proceeds of sale is used as a reason to deny a direct and immediate link to the exempt share sale, all of which we say is wrong for reasons I will come to. Same bundle, please. Could we turn to tab 6? And I think picking up at page 98. So this is Authorities Bundle 1, tab 6, page 98.
Sorry, where are we going next? We're going to
Same Authorities Bundle.
Authorities.
Yes, sorry.
Or core bundle 6.
Core bundle 6. I'm confused.
So we're going to
Core
the
bundle
Upper
6,
Tribunal now.
same bundle.
Upper Tribunal.
Upper Tribunal decision. Tab 6,
Thank you, got it.
page 98. I may pick up at 99. If I can invite the court, of course, to read, in particular in court's own time, paragraph 60 to 66, I think the most important points are really at page 99. There is a similar analysis to the First Tier Tribunal's analysis of the case law, which we say is wrong for reasons I will come to, but at 65, we see again the Upper Tribunal there relying upon part of the analysis in Franke Smart, what Lord Hodge said there, and in the quotation, paragraph 43, toward the end, we see what it is, as understood by the Supreme Court, that the CJU has said needs to happen in this sort of case where we have specific supply versus potential downstream activity using the inputs. The final 3 lines of paragraph 43, it held that the referring court should take into account of all the circumstances surrounding the transactions to determine whether the costs incurred were likely to be incorporated in the price of the shares sold, or whether they were among only the cross components of transactions within the scope of the taxable person's economic activities. So the tribunal has correctly directed itself that that is the test to be applied, but what it does at paragraph 66 and 67, where it endorses the tribunal, the First Tier Tribunal's approach, is it again misunderstands and mischaracterises what the direct and immediate link test is when dealing with an exempt sale of shares, such as this one. Paragraph 66 is the reasoning to support the rejection of a direct and immediate link at stage 1 to the exempt share sale. In SKF, the CJU at 62 and 73 instructed the National Court to determine this question, so where does the direct and immediate link lie, by reference to whether the taxable inputs were likely to be incorporated in the price of the shares or whether they were among the cross components of the downstream taxable transactions of the taxpayer. That's correct, but in the next sentence, in our view, it would be unusual to see such costs being reflected in the price paid for the shares in a standard share sale agreement. This would particularly be the case where the price is ascertained by a common share valuation techniques used for private companies, such as multiple earnings or net asset value. It would rarely be the case that the price of the shares in a standard arm's length sale would be determined on a cost plus basis, i.e. a margin of a cost, or for the costs of the sale to be specified as a component of the price. Although the cost of the fees incurred in relation to the disposal may, but not necessarily will, be paid out of the proceeds of sale, in most cases it is unlikely that the price itself will be influenced by the professional fees incurred by the seller. And as we see, that's the reasoning which leads to paragraph 67, where the approach of the First Tier Tribunal is approved. So
you say 66 is wrong because it's a complete misunderstanding of the cost component test.
correct, yes. Cost component incorporated into the price are all ways of saying direct and immediate link, which has a long established meaning, and it's true that in assessing that in relation to overheads, there has been an evolution in relation to looking at the ultimate purpose, but that's as far as it's gone.
And the counter, it would only be right, what's at 66 of the Upper Tribunal, if we were persuaded that SKF, in those paragraphs 62 and 73, had changed the direct and immediate link test to something different
Correct.
context of what they call these fundraising transactions where you've got an exempt share sale.
Exactly. Which we say it has not done. And of course, it's an illogical analysis because it would mean that a sale at market value, which didn't have the inputs specifically described as part of how the price has been arrived at in the objective documents like the contract, could not directly and immediately be linked to the input. But of course, suppliers can use inputs regardless of what the price is. They can use inputs if they're at or below market value. And if they say nothing in the contract as to how that price has been arrived at. So, the starting point, and I'm moving on now to talk about the authorities, as to illustrate, essentially all that I've said thus far. The starting point is, of course, the Principal VAT Directive. If we could turn, please, to the first volume of the authorities, and I am in the right bundle, I will probably stay there now for most, if not all, of the rest of today. Page 39, please.
We'll probably go into a second volume of authorities at some stage.
I think, well, true, yes. I will stay in the territory of authorities, but not necessarily in the one volume. So this is page 39 on the right-hand side, Article 168. At the most fundamental level, the directive, the direct and immediate link test is goods and services being used for the purposes of taxed transactions. There has to be that use for those purposes in order to get recovery of input tax. There's nothing there about any different test for any other type of transaction, and as we'll see from the case law, it is the same test for whether an exempt supply uses the inputs.
Can I ask an old person's question, which is that this is the 2006 directive. I think it might be worth tracking back to the 6th directive and the 1st directive, because I think that cost component comes from the 1st directive. And it just might be useful if we are going to be looking at, I think we are going to be looking at some ethical submissions, what does cost component mean as a facet of the direct and immediate link test? We ought to start right at the beginning, oughtn't we?
We certainly can do. I will say that the case law goes into lots of detail as to
Does
what
it?
those mean, but I'm
Okay.
very happy to do that.
Okay, well, if we're going to get there through the cases, let's not worry about
I will certainly.
ferreting out more. But
I would-
only to say that that's where my, as an old person, that's where my mind is taking me.
I would normally offer to do it over lunch. It may
No,
be
no.
overnight simply because getting to and from court takes me rather longer at the moment than it
If we're going to get
really
through the
does.
cases, it's fine. I didn't know where you were going to go next. But
There's
we just
certainly
keep
lots of
that as a
cases.
thread in mind.
Thank you.
anyway.
Absolutely. Tab should be same. No, it should be the second, I think, authorities bundle. Tab 24. If I'm right, I know the tabs are page 314. And that should be the beginning of the famous BLP case. If we can pick up at page 339. So, the second volume of the authorities, tab 24, but starting at 339. And if I could invite the court, please, to read paragraphs, probably starting at 23 to 26, please. Thank you. So we see there paragraph 24, which is, we say, the part of this reasoning which has changed in relation to overheads. But at 25, we see that there was, at this point, of course, a recognition by the court that you could have overheads, i.e. inputs that are used solely by the downstream business, and if directly immediately linked to it, and it is a taxable downstream business, then you can get recovery. But in relation to exempt transactions, if the direct immediate link is to the exempt transaction, there is no recovery. And that part of the decision has not, we say, changed. And there is no case which says that has changed in relation to use by an exempt transaction, or that there's been any change in the test for direct immediate link in that context. Same bundle, tab 25, please, is Midland. I'm going to take the court fairly briefly through a trio of cases before SKF, which show evolution and development of the law on overheads. I can deal with them fairly quickly. If you could turn, please, to page 360. So this case is Midland Bank. There was a partially exempt trader, and it acted for a client in a takeover, an attempted takeover. So it provided taxable services. Now, as it happened, the takeover fails, and there were solicitors' fees charged for various matters. Some of those solicitors' fees were an issue as to whether they were directly and immediately linked to that failed but taxable takeover set of services, or whether they were directly and immediately linked only to downstream activity, because that general business activity was partially exempt, and therefore there would need to be an apportionment. And what was perhaps of particular note about the legal services in that case that were an issue is that they weren't legal services advising on, for instance, how to perform the takeover services, but they related to that failed takeover because they were legal services provided in defending a legal dispute which arose out of the failed takeover. So there was a factual and a but-for link. They were certainly related to the failed takeover services. But the finding of the court is that while it is for the National Court to determine, there is a steer that there would not be a direct and immediate link to the specific, in this case, taxable set of services, the takeover services, because there isn't enough of a connection. So at page 360 and over the page, if I could invite the court, please, just to read paragraphs 30 and 31.
That suggests that the Article 2 of the First Directive, and quite possibly Article 2 of the Sixth Directive, refers to cost components.
Yes.
I think there's a suggestion in one of the authorities that Article 1 of the Principal VAT Directive also refers to cost components. We don't have that in the
I'm afraid we haven't included that in bundle, no. We've only included the principal VAT directive, but we will certainly look those out and provide them.
No, I think there is something in the principal VAT directive. Article 1(2), I think, might refer to cost components.
Yes, and I seem to think that was one of the authorities cited in the skeletons, which I suggested we took out as uncontroversial, and I now regret that decision in my attempt to slim down the authorities bundle. We will certainly dig that out and for the call.
Thank you.
But what is interesting here is, first of all, of course, we see the contrast between the specific and the general. We see BLP being relied upon, and in particular in 31. Although this is just after B, although the expenditure incurred in order to obtain the aforementioned services is the consequence of the output transaction, that's the specific supply, the fact remains that it is not generally part of the cost components of the output transaction, which Article 2 of the First Directive nonetheless requires. Such services do not therefore have any direct and immediate link with the output transaction. So that is an example. These were legal costs of defending the fallout of the services in the failed transaction, where there is clearly recognition that you can have services that are a consequence of, factually related to, causatively linked to a specific transaction, but they are not directly and immediately linked to it because they're not actually used in the transaction, and therefore there can be overheads. And I stress that because one of the questions perfectly reasonably raised by Mr. Firth in his skeleton is he says, when can you have costs which relate to an exempt share sale but are not directly and immediately linked to it? Because he reads paragraph 68 of SKF as meaning they can be directly and immediately linked to it, but nevertheless they are to be treated as part of the general costs. And this is just one example, I'll give some more later, but clearly there could be an exempt share sale where there is then a legal dispute following that. Breach of warranty, for instance, could be alleged, which could give rise to very similar legal costs, which would not be directly and immediately linked to the exempt share sale because they didn't actually get used in that share sale. They didn't facilitate it, they didn't advise upon it, but they're related to it.
So, cost component means what? A cost component of an output of a transaction.
It means the same as direct and immediate link, and it doesn't mean that it must be paid for out of the proceeds of it, but it means that in the chain of events, that input has been used in it. So
it's a cost that you incur
yes.
in order to facilitate the transaction, or in order to
yes.
in order to generate the transaction.
Yes, it is a cost.
It has to be a cost.
It's got to be a cost, and it's a component because it is part of, it is used in, it is sometimes described as incorporated into the price, but as touched on and I'll come back to, that doesn't mean the price of the output necessarily is increased to cover it or necessarily includes an allocation.
And presumably, it doesn't mean that the price has to actually cover all the costs. If you have a business which sells an item at a loss,
yes.
It's still entitled, presumably, to deduct its input costs.
Exactly, yes.
If I buy, suppose I take a very simple case. I'm a market trader selling apples. The cost component of my apples are normally going to be the wholesale price of buying the apples and some very minor overheads, the paper bags and the wages of my staff and the pitch rent for the stall and so on. And one would hope that you would be able to sell your apples at a sufficient price to cover all those, to leave you with a profit. But if at the end of the day you're left with apples that haven't been sold and you mark them down to less than half what you paid for them, the costs of buying them don't get fed through into the price in any real sense, but they're still what it's cost you to get to the stage of selling the apples. And presumably you're still entitled to deduct the input tax. I know there's no input tax on apples.
And there could be a deliberate loss leading type of supply you can sell something at below market value. All of those can be output transactions. They can all use costs, because of course you can use goods and services in order to make that output supply. The price doesn't need to be affected at all in order for there to be recovery of the input tax. That is
So you would say those are all cost components, even if the output price, the price of the output transaction doesn't cover all those costs. They don't need to be components in the sense that the price of the output transaction is made up of A plus B plus C plus a profit, because it may not be.
Yes. Subject obviously to questions of things like abuse.
Yes.
But yes, broadly, yes.
So
That
the
is-
phrase cost component is a metaphor.
It's another way of saying a cost that has been used in the making of the output supply.
But it doesn't mean literally. Here you have the price you're selling it for, and it is made up literally
Yes.
of all these items. So
Exactly.
in that sense, it's a metaphor.
Yes, exactly. Yes, yes, or a shorthand. Yes. So I've taken you to Midland Bank just as a good example, I hope, of the kind of input which can be related to an output transaction, a specific transaction, but not actually directly and immediately linked to it, and a real commercially normal type of input as well. And also an example of the development of the CJU case law on the test for overheads.
So your point really is that the tribunals have used the phrase cost components in an over-literal way.
Correct. Yes, exactly. And an overly narrow way,
Yeah.
which isn't found anywhere in authority.
But except in SKF, which we will have to come back to. So there is that quite difficult passage, isn't there, in SKF, that talks about cost component. So I suppose the question is whether the court were intending to say, well, it's the same point I put to you before, that something different was happening in this context, or whether that was just the court's own shorthand for everything we already know about the test.
Yes, and my position will be it is the court's own shorthand, because in other passages, when talking about precisely the same test, such as paragraph 71, the court just talks about direct and immediate link. It doesn't say different, modified test, etc. Briefly, Abbey, same bundle, tab 26, and if we could pick up page 382. Paragraph 42. So Abbey, the facts of Abbey are there was a transfer of a going concern, and as a consequence of legislation, that is not a supply in the course of economic activity. There are various inputs purchased which were involved in affecting the transfer of a lease, which was the transfer of the going concern or part thereof, and Abbey sought to recover them. There was, therefore, no possible direct and immediate link to a specific supply for consideration in the course of economic activity, because a transfer of a going concern is designated as not being such a supply. And so the question was simply whether or not there could be the direct and immediate link to the general business activity. Could I ask the court, please, to read paragraph 42, which should be at the top of page 382, the dispositive. So, fairly straightforward, but what we're seeing here is a recognition that where we don't have any possible direct and immediate link to a specific transaction, then there can be the input treated as an overhead because it's directly and immediately linked to the the general business activity, and the ordinary consequences therefore follow. If it's an overhead, then there has to be apportionment if it's a partially exempt trader and similar. Or if it's not an overhead, but if there's a clear defined part of the economic activity only using the input, then that will determine the recoverability. That's technic, same bundle. In fact, straight over the page is the first page.
Just before you leave, Abby, I noticed that in the paragraph you asked us to read, there's a reference to the costs incurred by the transferor for services acquired in order to effect that transfer. And that's effectively what you say a cost component or direct and immediate link is. It's costs incurred for services acquired in order to effect the transfer.
Yes. I think it could in some facts be slightly wider in that they wouldn't necessarily have to be services that were necessary to perform the transfer, provided that they were used in the transfer.
Yes.
But yes, essentially. Rechtstechnik is a third example of the development of the question of overheads being directly, well, inputs being directly and immediately linked to downstream businesses and thus overheads. If we could pick up, please, at page 400 would be the best. So just as that's being turned up, the background is that there's a company with a downstream taxable business, and it's important to say factually what it does here is different from our case. It doesn't sell some shares, as happens in our case. It lists its own shares in itself, and issues new shares. So it lists the shares on a stock exchange and issues new shares. And it seeks to recover the input tax on services supplied in connection with that listing and the issue. So, as a matter of the analysis of what's gone on, there's no economic activity, because listing your own shares and issuing your own shares is not economic activity. That's paragraph 26, but if we pick up, as I say, at page 400, actually probably, apologies, 399, I have the wrong page there, 399. And if I could invite the court please to read paragraph 36. So here we see again the now fairly conventional recognition that you can have use of inputs or inputs connected to a non-economic activity, which nevertheless are directly and immediately linked to downstream activity. We don't see any special regime for fundraising as opposed to any other type of overhead. And we don't see anything said here suggesting that it wouldn't matter if there was a direct and immediate link to a specific exempt transaction. But it's fair to say in the cases before SKF, there isn't really examination of the question of a connection with or relationship to an exempt transaction, and whether that means that inputs so connected to are blocked from giving rise to recoverable input tax, or whether they aren't. And that's where
BLP, because that was the fact pattern of BLP, wasn't it? That's exactly that case, isn't it? But
yes, but not post the developments in relation to how we approach overheads.
No.
So we get to SKF, same bundle, tab 28, and the first paragraph I'd like to start at, I think, is page 430. So the facts of SKF were that SKF was a parent company supplying services to its subsidiaries, and to obtain funds to finance taxable activities of the group, SKF plans to dispose of some shares in subsidiaries, and it seeks a preliminary ruling on whether the input tax connected to that will be recoverable or not. The specific services were share valuation, assistance with negotiations, and specialised legal advice in drafting contracts. And if we can pick up then at page 430.
Is it of any assistance to look at what the Advocate General said? Because the Advocate General seems to have taken a very straightforward view that it's all covered by VLP. And the court itself has taken a more nuanced view.
Correct, yes. We can, if that's of assistance. For time, I was planning only to go to what the court has
Well, I
to say,
noticed that Lord Hodge and
Yes.
Frank Smart makes the point
Yes.
that the court didn't simply adopt what the Advocate General said. And I think that
It's-
one of the points on which this appeal is likely to turn is in precisely which way the court in SKF disagreed with the Advocate General.
Yes. And our position is we can certainly do that, perhaps picking up at page 420, just to read the conclusion of the Advocate General.
Well, I think it starts at 72 and 73, where he says the answer to that question must be no. That's whether you can treat the inputs as part of general overheads. And then at 73, he refers to VLP and says, well, you can only do it if it falls entirely outside the scope of VAT, which this doesn't. That's effectively what the Advocate General said, is it not?
And the paragraph which is particularly referred to by Lord Hodge as having been somewhat modified, I understand is the one at page 421,
Yes.
but it is a subparagraph, paragraph 89, which begins on 420. For the reasons set out above, I propose that the court answer the questions referred by the Swedish court for preliminary ruling as follows. And over the page at 3, I can just invite the court to read that passage.
Yes, thank you. That's helpful.
So, as I understand what's being said there, a taxable person who has acquired supplies of services in order to carry out a disposal of shares, etc., and with which those services have a direct and immediate link, does not have the right to deduct input VAT on those services, even when the disposal of shares is a transaction which contributes to the objective of restructuring the taxable person's industrial activities. And my understanding is that it isn't that the court goes terribly far away from that, but what it says is there needs to be, this rather presupposes that there is a direct and immediate link if the taxable person has acquired the supplies of services in order to carry out the disposal of the shares. And what the court is saying is there isn't always that direct and immediate link simply because you have that factual connection. It's for the national court to determine.
So you can't assume it.
You can't
It's
assume
a question of fact, fact and law for the national court.
Yes.
That's where you.
I think so.
Whereas might it be? I don't know. Might it be said that the AG had sort of assumed something to be the case?
I think that's, my lady, that's my understanding, because there isn't any great shift in difference, in position, but the Advocate General there very sweepingly is saying if you've acquired the supplies of services to carry out the disposal, then, well, and there is that direct and immediate link, then it follows you can't recover. And the CJU is saying you have to unpick quite carefully where the direct and immediate link is in a case like this one, because simply because services required in relation to an exempt transaction doesn't automatically mean that that doesn't tell us where the direct immediate link lies. You have to perform the ordinary analysis. So, in the judgment, please, page 429. Could I invite the court, please, to read? Perhaps it might be helpful, just for context, same page, but to read paragraph 54. So the court will see there that the difficulty that the Swedish court is finding itself in is that it has made the in fact impermissible finding that on the one hand there may be a direct and immediate link between the disposal of the shares, which is exempt, but also there may be incorporation into the price of the downstream taxable activities. And that's even clearer slightly further on at 61. I'm jumping about slightly. If you read 61 at page 430, in the present case, the referring court describes the costs linked to the services acquired by SKF first as directly attributable to the disposal of shares, and second, as forming part of the general costs associated with SKF.
Sorry, where are you?
I do apologise, page 430, paragraph 61.
Thank you.
So it's made a finding which I'll come on to say is an impossible one. The court tells us that essentially there's a direct and immediate link with both the specific and the general, which there can't be. Could I invite the court, please, to read paragraphs 57 and down to 59, pausing there.
5759.
57 to 59.
Yeah.
So at 57 and 58, we see the court describing two different ways for input tax to be recovered, either a direct immediate link to a specific supply or to general downstream business activity. And at 58, we see expressly it's stated that it can't be both. It's one or the other, because we have 58. It is, however, also accepted that a taxable person has a right to deduct even where there is no direct immediate link between a particular input and output transaction, and so on, because they do have a direct immediate link to the taxable person's economic activity. 59 is, of course, important, because 59 tells us that the old rules haven't changed in relation to where goods or services have been used for the purposes of transactions that are exempt. You cannot recover your input tax. It doesn't caveat that, nor does it say that there is a different test of use in relation to an exempt transaction, nor does it use cost component or incorporated into the price at that point. It just uses the language of the directive used for the purposes of. And it's an important passage because the Supreme Court, as I'll go to later, comments upon it and acknowledges that that applies both in relation to if there is use in an exempt downstream business, but also if there's use in an exempt specific initial transaction. 60 is important. It follows that whether there is a right to deduct is determined by the nature of the output transactions to which the input transactions are assigned. Accordingly, there's a right to deduct when the input transaction subject to VAT has a direct and immediate link with one or more output transactions, giving rise to the right to deduct. If that's not the case, it's necessary to examine whether the costs incurred to acquire the goods or services are part of the general costs linked to the taxable person's overall economic activity. Critically, just above G, in either case, whether there is a direct and immediate link is based on the premise that the cost of the input services is incorporated either in the cost of particular output transactions or in the cost of goods or services supplied by the taxable person as part of his economic activities. So the court there is using incorporated in the cost of as a synonym for direct and immediate link, and it's not suggesting that there is any different test, for example, dealing with any particular type of transaction in order to ascertain whether that is established on the facts of the case.
So this was the passage that I had in mind,
Yes.
which I paused over. Just, I want to be absolutely crystal clear. Your submission is that it's not, this isn't reinventing anything. This is just picking up old threads and saying it's all to do with cost components, direct and immediate link, use. It's the same package.
Absolutely, my lady, yes. And we see that over and over again, that these synonyms are used. So, as I say, in 59, we've just seen used for the purposes, specifically in relation to exempt transactions. So we know that's the old ordinary test. Here, we've got incorporated into the cost. 61 we've looked at already. That is just explaining the impossible scenario that the court has got itself into, the Swedish court, by finding apparently a direct and immediate link, both to specific and to general. And at 62, we see the CJU saying it's not possible for it to disentangle where the direct and immediate link lies from what information it's been given. At the end, in order to establish whether there is such a direct and immediate link, it is necessary to ascertain whether the costs incurred are likely to be incorporated in the price of the shares, which SKF intends to sell, whether they're only among the cost components of SKF's products. So, two important points to draw from that. That is a very clear statement that it's one or the other. Swedish court's gone wrong in saying both. Our tribunals have gone wrong in saying both because they've found use in the exempt share sale, but also direct and immediate link downstream. And to stress that here is the direct and immediate link test described in the last 4 lines as costs being incorporated in the price of the shares or only among the cost components. Again, the test is described variably using those terms throughout the judgment. Sometimes cost component in relation to downstream, sometimes incorporated into the price, sometimes direct and immediate links, sometimes used for the purposes. They all seem to mean the same thing. If cost component meant that the price had to include, the price of the output had to be increased to cover the cost of the input, or had to at least have in its consideration a specific allocation for the cost of the input, then on our facts there would be no direct and immediate link possible in relation to downstream activity, because there's no dispute factually here that the inputs were paid out of the proceeds of the share sale, not out of, not allocated in, the cost of hotel rooms, which is the general business activity. 63 is simply the court reiterating that it can't unpick facts and determine where the direct immediate link lies. Could I invite the court please to read 64 down to 68, which is a very important passage. So, of
But you
critical
say in relation to 68 that you can't reach that conclusion without first asking the antecedent question about the cost components of the price that you receive for the shares.
My lady, absolutely.
Yeah.
And if we look at perhaps 66 and 68, which talk to each other, 68 is the conclusion. 66, if the right to deduct input VAT paid on consultancy costs relating to, not cost component of, incorporated into the price, directly, immediately linked to, relating to a disposal of shares, which is exempted, because of involvement in the management of the company whose shares are sold was not allowed, and if the right to deduct input VAT in respect of such costs relating to a disposal, which is outside the scope of VAT, was allowed, on the grounds that those costs constitute general costs of the taxable person, that would amount to treating objectively similar transactions differently for tax purposes, and would be an infringement of the principle of neutrality. So at 68, what is the court saying? If we've got to the point where we've determined that the costs relating to, not directly immediately linked to, relating to disposal for shareholdings, are considered to form part of the taxable person's general costs. So I'll just pause there. This is telling us that the fiscal neutrality concern is at stage 2. If we're in the territory that there's only a direct and immediate link with general business activity, not with the exempt or otherwise transaction, the specific transaction. It's very notable that the court is avoiding using directly and immediately linked to. And Mr. Firth, with respect, is incorrect to interpret this as saying saying essentially that all inputs connected to or even directly and immediately linked in the conventional sense to the exempt transaction are to be found to be directly and immediately linked to downstream taxable activity provided the objective purpose is there, because it simply doesn't say that.
So the inputs, can I just track back a bit? I haven't quite got the point about the significance of talking about input tax or costs related to, but we'll come back to that. Is the point of significance that, in fact, I've only just seen now in 68, it follows that important word if the consultancy costs relating to disposals form part of the taxable person's general costs.
Yes.
Those are the two words you need to highlight out of 68. Then you're in the same world as a Midland case or a Credstone case.
Correct.
But didn't it, in a sense, the court only need to say that because we know that already, don't we? I mean, maybe they seem to go to town a bit, if that's all they're saying.
I think that the problem arose because the Swedish court had confusingly found that there was a direct immediate link at both points, which is impossible. And it's important to say as well that at least since the case law had evolved in relation to overheads, there hadn't been an examination of whether costs relating to, but not directly and immediately linked to exempt transactions could be overheads. And here the court is saying, yes, they can be, provided that the direct and immediate link is with the general taxable downstream activity. And only that. You can't have both. And I think it's important to unpack why it gets to that, because I anticipate that what Mr. Firth will say is, well, you need to follow his interpretation, because he says that the problem, the fiscal neutrality danger, is at stage 1 in relation to treating costs used in an exempt share sale differently from costs that are not that are involved in or used in something which is not an economic activity, for example. And that's wrong. We know that, first, because 68 tells us, and 66 tells us, that the concern of the CJU is about a fiscal neutrality breach at stage 2, i.e. on the question of whether or not inputs are overheads, as opposed to whether or not they are directly immediately linked to a specific transaction. Fiscal neutrality requires the same tax treatment, not for all supplies, but for similar supplies from the perspective of the consumer. So if there is a difference, for instance, one that's hardwired into the directive, fiscal neutrality will not say that difference must be removed. So, case in point, if an exempt transaction uses some inputs, a hard line in the directive exists saying there can be no recovery. And that's because they are fundamentally different from taxable supplies. There is no output tax charged in an exempt transaction. For example, there is a hard line in the directive saying that there should be a fiscal difference in relation to recovery of input tax. That was not the concern of the CJU. Its concern was if we got to the point where there was no specific supply using the inputs, but there was the question of whether there was a direct and immediate link to the downstream taxable activity, then it didn't matter if the inputs related to, were caused by, connected with an exempt activity, exempt transaction, versus one which is not an economic activity.
Can we just go back over to 66, which is where the court identifies the lack of parity? I think this is what they're saying. This is what the neutrality balance needs to be. So if you've got the right to deduct input tax on consultancy costs, inputs, relating to the share sale, an exempt share sale, and it's exempt because of the involvement of management in the company. If that wasn't allowed, it's that beginning bit that I think has caused me some difficulty. So let's start again. If the right to deduct in these sorts of exempt share sale wasn't allowed, even though you could have a right to deduct where you had an outside the scope activity and that was allowed, then that would create a breach of fiscal neutrality. So can we just unpack exactly what they're saying? Is your argument that they're comparing not all cases where there is exempt share sale willy-nilly, but just those cases where you might have an exempt share sale, but you still come to the factual conclusion that the input tax in question was attributable not to the exempt share sale, but to something beyond that?
Correct, my lady, correct.
My mind.
I think that's correct, yes.
That's why the phrase relating to is used rather than some other phrase.
Yeah,
Exactly,
can
my
Can we
lady.
go over that again?
So it's not a
Yes.
direct and immediate link, it's a
Yes.
less close link than
Exactly. So examples of that, real normal commercial examples of that include the Midland Bank situation I've spoken of before, where there are legal costs which are arising out of, but for caused by a transaction, but not actually directly immediately linked to it. Another example would be if there is a single supply which forms the input of something like accountancy advice or legal advice, which includes advice about the share sale, but overall that single supply is much broader and therefore is not directly immediately linked to it because it may concern matters like broad restructuring of the business as a whole, how contracts should be amended after the share sale, those sorts of matters. Again, that would clearly be an input cost which related to the sale of the shares. It might even have advised on how to perform the sale of the shares, but because the overall character of that input as a single supply is much broader than that, there wouldn't be that direct and immediate link. But it would still be an input relating to the sale of the shares, factually. And at 66, I perhaps misunderstood you, my lady. It may simply be my misunderstanding, but what's being contrasted there is that if you have sale of shares and there is involvement in the management of the company, that makes it an exempt sale of shares, whereas if there isn't that management, then it may be an outside the scope, outside of economic activity situation. And what's being said is that they should be treated fiscally the same as one another, where in the latter case input VAT is being recovered on the ground that those costs constitute general costs of the taxable person. So I understand on the ground that those costs constitute general costs of the taxable person to be telling us we're in stage 2, we haven't got a direct immediate link to a particular transaction, and in that case, the objectively similar transactions that shouldn't be treated differently are those general downstream transactions if they are both taxable. Because if we forget about any specific supply, it drops out of the equation here. We have inputs that are just as much used in the downstream taxable business, whether they have a factual connection to something exempt or something non-economic. And therefore, taxable business using inputs should be treated in a fiscally neutral way, despite the factual background being somewhat different to those inputs.
So is this a sort of rejection? I just wondered, we looked at the AG and we thought that he was a bit automatic in his stance.
Yes.
Is this a reject? This is where they say the AG hasn't got it quite right, because he, I mean, reading a lot in, I realise that, but what they're saying is you can't simply assume, it's the assumption point, you can't assume that if there's an exempt share sale, that mops out all the input tax that relates to that share.
Exactly.
You still have to do the exercise, and it's still an open door to say that it all, if you do get to stage 2, it all depends on facts.
Exactly, yes. But you do have to apply the ordinary direct and immediate link test, and at 68 we see the conclusion that yes, at stage 2 there can be a fiscal neutrality problem if we, as you say, my lady, see the mere fact of there being an exempt initial transaction mopping up all that input tax, as opposed to engaging with, is it directly and immediately linked to the inputs? And if it's not, then you cannot treat those two taxable downstream businesses differently, because they're both using the same type of input. It's directly and immediately linked in both cases, and therefore they should get to the same outcome. Not at stage 1, because if the use is in an exempt transaction, the directive and all the authorities say that's the end of the story. There is a difference in treatment, but no breach of fiscal neutrality, because an exempt supply using inputs is different from a taxable supply using inputs or something outside the scope using inputs.
And in 68, the phrase relating to disposals is used again, picking up the same phrase in 66.
My lady, exactly, yes, which is no accident. So there's nothing here that says modify the direct and immediate link test. There's nothing here that says, as Mr. Firth, I think, says, you don't need to engage in stage 1 at all. It doesn't matter how conventionally the inputs are used in exempt share sale, they're all swept up in the general business activity, provided the purpose is there. There's nothing that says that.
That's where he goes too far, because you say he sort of turns the automaticness of the AG on its head, and he says it's automatically the other way.
Yes.
In other words, it's all in overheads.
Yes.
AG said it was automatically all in the exempt share sale. And you say that's where he goes wrong.
Yes.
Or where the FTT and the Upper Tribunal went wrong, perhaps I should more correctly say. Because there's nothing automatic about any of this.
Yes. Yes. There has to be.
Open.
Yes.
It all depends.
Yes, absolutely. Yes.
Why do they say at 64, in order to give a useful answer to the referring court? I mean, the question for the referring court, which they've just identified in 63, is to apply the direct and immediate link test to the facts of the case.
Yes.
In other words, as you point out, 61, the referring court seems to have treated the costs as both directly attributable to the disposal of shares and forming part of the general costs. And you can't do that, so they've sent it back to the referring court to apply the direct and immediate link test. If we'd stopped at paragraph 63, we wouldn't have any difficulty in understanding this judgment at all. So why do they go on and say, and here's some helpful comments. I mean, they don't seem to have anything to do on your submission with the application of a direct and immediate link test.
I think I would say that they do, in that they indicate that there is no, that it's improper if there is no direct and immediate link to a specific transaction to regard relationships between the inputs and any specific transaction as affecting whether or not there's a direct and immediate link between input and general business I do accept that it isn't a case, on my reading, that takes the law very far. It seems to be essentially reiterating principles that are familiar. But it may be, because the Swedish court had gone quite significantly wrong in making seemingly two direct and immediate link findings in relation to a single use input, that the CJU felt the need to elaborate a bit further. And it may be that it felt the need to clarify the extent to which BLP is still correct, which is, it is in relation to use in a specific exempt transaction, but there has been this evolution, which is how I understand the Supreme Court in Frank A. Smart analyses the case.
Okay, thank you.
So essentially they're saying the starting point is the direct and immediate link test.
Yes.
And in a case like this, they then go on to make some further observations about what the upshot might be if there isn't a direct and immediate link to the sale transaction.
Could you just repeat that?
Well,
again? I'm so sorry.
So they're saying in 63 the starting point is the direct and immediate link test. So I mean there are a number of possibilities. If the factual finding is that there's a direct and immediate link to the sale transaction, you stop there.
Yes.
And this is all stuff about what might arise if you don't stop there.
Exactly. Yes, my lady. 69 is also helpful in understanding what the fiscal neutrality worry or concern was. That interpretation is borne out by the purpose of the common system introduced by the 6th Directive, which is in particular to secure equal treatment for taxable persons, and various citations. That principle would be disregarded if the costs incurred by a parent company managing group of companies in connection with the sale of shares, which is part of its economic activity, were taxable, while a holding company which carries out the same transaction outside the scope of VAT would be entitled to deduct VAT on the same costs by reason of the fact that those costs form part of the general costs of its overall economic activity. So again, I read that last part as indicating the location of the concern. 71 is critical, and I would stress it as being really at the heart of HMRC's submissions in both tribunals, but hasn't until now had any significant commentary from either tribunal on it. This, we say, is reiteration of both the need for that two-stage process and secondly for there being no modification of the direct and immediate link test in relation to specific exempt transactions. In the case, in the main proceedings, while it is admittedly true, as correctly argued by various governments and court, that a disposal of shares which is exempt from VAT does not give rise to a right to deduct, the fact remains that that interpretation holds true only if a direct and immediate link is established between the input services and the exempted disposal of shares as an output transaction. So pausing there, the court is saying the same rule holds true, direct and immediate link to the exempt transaction. That is the end of the question of recovery. And that is what the tribunals should have found in this case. Having found use, having found that the shares, the inputs were all part of the process of selling the shares, that should have been the end of it. If, on the other hand, there is no such link, pause there, it's either or. Our tribunals should have stopped having applied the conventional test. You can only have, obviously, an input can only be an overhead if it isn't used in a specific transaction, but it's used in the general business.
And that's helpful guidance for the referring court, because the referring court got itself in a muddle about that.
Precisely, my lady, yes. If, on the other hand, there is no such link and the cost of the input transactions is incorporated in the prices of SKF's products, the right to deduct VAT charged on the input services should be allowed. I just draw attention there to incorporated in the prices of the downstream business. Again, that is a synonym for direct and immediate link. It doesn't mean anything different. I think I said this already, but if that meant that the prices had to be raised or have a carve out for the inputs, then there would be no possible direct and immediate link to the downstream taxable business here, because the evidence is not that the hotel rooms became more expensive. 72 is important. It must lastly be stated that there is a right to deduct input VAT in respect of services carried out in connection with financial transactions, if the capital acquired by means of those transactions is used in connection with the economic activities of the person concerned. Furthermore, costs associated with input services have a direct and immediate link to the taxable person's economic activities in circumstances where they are solely attributable to downstream activities and consequently are among only the cost components of transactions within the scope of those activities. And I stress the words solely and only to reiterate, you cannot have an overhead if there is use in a specific transaction. So that is the two-stage test and the impossibility of both the Swedish court's findings and the tribunal's findings in this case, where we have use of the inputs as all part of the shared sale. So what do we take from SKF in summary? As I say, a two-stage test. You cannot have a direct and immediate link both with specific and with general. There's no change to the test to direct and immediate link for an exempt specific supply. Paragraphs 59 and 71 tell us the same old rules apply, that if an exempt transaction uses the inputs, is directly and immediately linked to them, there is no recovery, regardless of what the overall objective purpose of incurring those inputs might be. And the fiscal neutrality problem is at stage 2. It's not at stage 1, that being, it is at the point where there is no specific supply directly and immediately linked to the inputs, but there is potentially to downstream general business activity. I don't think we need to turn to it just for time, but for the court's note, it may be worth noting that the Swedish court in SKF understood paragraph 71 as we do, and not didn't understand the case as Mr. Firth appears to do, because in the same bundle, it is at page 5, 6.1 to 2, it cites paragraph 71. It goes on where the evidence allowed to find that all of the costs on the facts of that case were directly and immediately linked to the exempt share sale. But it is fair to say there were some where it didn't have evidence to make a determination. So, while of course not binding, we take some reassurance from the fact that the Swedish court understood SKF in what we think is the straightforward, plain English way in which the words were intended. A very brief look at a case.
So you said the Swedish court got it right?
Yes.
And that was
Yes.
back in 2010?
Yes.
Nobody appealed it again or re-referred it or anything like that?
Nope. Nope. A very quick look at a case which is in the same hard copy bundle, tab 29. If we return please to page 459. This is a case about characterisation of some services, portfolio management services to investors, whether they were exempt and were place of supply issues. So the facts are not hugely relevant, but I take you to paragraph 45 on page 549 in order to emphasise what fiscal neutrality will not do, which is erase hard lines in the directive which require different categories supplied differently. Could I just invite the court to read that passage, please? So I, of course, take the point that this is talking about whether fiscal neutrality can expand an exemption, but effectively what the court is saying is, no, what fiscal neutrality does is allows us to interpret legislation, not to change legislation because of a perceived lack of neutrality, if that is one of the walls erected in the legislation. And here, clearly, exemption is a very hard wall erected in the legislation that doesn't, when an input is used in exempt supply, give rise to the right to deduct the input tax. And that is not something which fiscal neutrality can alter, and yet that is the effect of what Mr. Firth is arguing for. And so,
Going back to that passage we looked at in
yes,
BLP, where they talked about taxpayers having choices about how they want to do
Yes.
things and all that. So the point is that if you make an exempt supply, you say you're stuck with it and its consequences.
Correct.
And you can't complain that somebody who hadn't made an exempt supply got preferential tax treatment, because that's
Correct, my
just
lady.
nothing to do with anything.
correct. Which is why what's said in SKF about fiscal neutrality is so limited, because it's only dealing with the circumstance where you're contrasting taxable downstream business A and taxable downstream business B, both making taxable supplies, both using inputs, because we forget about any specific supply, we've ruled out any specific supply using the input, and therefore they must be treated in a fiscally neutral way. It doesn't matter that in the history there may be an exempt supply somewhere, because it hasn't used the input. But if it has, there is a difference in treatment, because we're not dealing with similar supplies, exempt versus taxable. Sveda, very briefly before I come to one or two other cases, that should be in, I think, the same volume, yes, page 477, please. It's just the facts. Perhaps we could pick up at page 480. So Sveda is another case which goes to the CJU dealing with the question of overheads. The facts are there was a footpath that was built, and that of course caused costs to be incurred. It had exhibits at the side celebrating Baltic mythology, and the idea was that the public would be allowed to use this path free of charge. So there's no supply for consideration because the public aren't paying anything. But there are downstream taxable activities selling various items to the public who come to enjoy the path. So the question is, can the costs of building that path be inputs in the general business activity? And unfortunately, I've just had a crash. A moment. Wonderful. So at page 480, could I invite the court please to read paragraphs 27 and 28? So that passage is reiterating the conventional two ways in which you can get recovery of your input tax. At paragraph 32 is some critical wording right at the bottom of the page. In that regard, the case law of the court makes it clear that where goods or services acquired by a taxable person are used for the purposes of transactions that are exempt or do not fall within the scope of that, no output tax can be collected or input tax deducted. In both cases, the direct and immediate link between the input expenditure incurred and the economic activity subsequently carried out by the taxable person is severed. So we see the court several years after SKF reiterating that conventional approach, which is totally at odds with what the tribunals have found in this case. We also see that the court simply uses terms like used for the purposes from the directive. It doesn't suggest any narrow or special test, any fundraising exception. That passage there cannot sit with what the tribunals have found or what Mr. Firth is arguing for, because it tells us there is use in the exempt transaction. That's the end of the story for recovery. At 33, there's discussion of the fact that what had happened in making the path available to the public was not an exempt activity. And at 34, therefore, immediate use of capital goods free of charge does not, in circumstances such as those in the main proceedings, affect the existence of the direct immediate link between input and output transactions or with the taxable person's economic activities as a whole. Consequently, that use has no effect on whether a right to deduct VAT exists. So the court there is saying we have an activity using input, but it's not a supply for consideration, and therefore it can be looked through, and the question of whether the inputs in building the path or overheads can be answered. So that is a case which we say continues the analysis of how you approach the test of overheads, and which reiterates that nothing has changed in relation to exempt supplies using inputs, whether in fundraising or otherwise. There is no recovery of the input tax. Nothing there, for example, to suggest that BLP, to that extent, has changed in any way. Back to, I think, volume 1 of the authorities, please, tab 14, page 119. While the court is turning that up, this is the Associated Newspapers case, page 119, 119. And there are a number of different questions here. In relation to input tax, there was a question of whether a promotional scheme in which vouchers were given away free of charge, but nevertheless it cost something to produce the vouchers and to give them away, so there were inputs, whether the cost of providing those vouchers could be overhead. So again, no supply for consideration using the inputs, but the question of whether or not there can be downstream a direct and immediate link. And at 119 at the bottom of the page, please could I invite the court to read paragraph 37 and open the page. So this is the Court of Appeal, and it's analysing the distinction between direct and immediate link in relation to specific versus downstream activity. The first sentence is interesting. The decision confirms that to be treated as a cost component of the business as a whole, notice cost component used there just to mean direct and immediate link, there must be a direct and immediate link with the whole of the taxable person's economic activity rather than any particular supply, so either or. BLP, of course, is being cited in the middle, and so here we see in 2017 it's still being regarded as good law, except to the extent it's been modified. And toward the end of the passage is a description of how the tribunal or the court should go about determining where the direct and immediate link lies. At the end, halfway between B and C, but when goods or services are required specifically in order to satisfy an order from a customer or to make some other identifiable supply, their treatment as cost components of that particular supply may become unavoidable. seems to us to be a reiteration that when we're looking at direct immediate link and the specific supply, it is the ordinary test use to make some other identifiable supply. Well, on our facts, we've got use of the inputs to make the sale of the shares, to perform the sale of the shares. So again, Court of Appeal reiterating that yes, there's been an innovation in relation to overheads, but not in relation to specific supplies. Franke Smart, I will need to say a little bit more about. So I don't intend to turn it up, but for the court's note, it's worth noting part of the First Tier Tribunal decision, which tells us in terms that right from the start, it was a case where there was no specific supply for consideration in the course of economic activity, which could ever have a direct immediate link. And that, for your note, is tab 12, and at page 88, paragraph 41, the First Tier Tribunal describes there that there's no specific supply. And that's because the facts of Franke Smart are that the taxpayer purchased called single farm payment entitlement units. And what these units did, if they were held by a farming business, is that it entitled them to various payments by the Scottish Government for use in farming. So they purchased the units, that's the input being bought, but then the taxpayer isn't making any supply. It simply holds the units and receives government money. It isn't providing a service or goods to the government. So unlike in Sveda, where it's a no consideration case in the initial activity, here it's a no supply case in the initial activity. So there never could be that direct and immediate link. The objective purpose for the purchase of those units was to develop the taxable downstream business. So the question was, is there a direct and immediate link to the downstream taxable business or not? And it's correct to say, as I'm sure Mr. Firth will say, that HMRC were unsuccessful in their argument. They argued that use in the non-economic activity of holding the units prevented a direct and immediate link to the downstream activities. And it's that which the court disagreed with. Now, it is true that there are passages that address exempt supplies, and I will take some time to go through them. But we do start our analysis of this case by acknowledging that it isn't a case about an initial exempt transaction. And so it's fairly limited in what it says about them. Most of the analysis is addressing the facts of the case, unsurprisingly, where there was no supply initially. There was an activity, but not a supply for consideration in the course of economic activity.
There's no economic activity to start with, was there? It was a purchase in. There was nothing that happened.
Yes.
There's no sale of anything.
Yes.
You bought something, sat on it.
Yes.
The question was whether the inputs associated with buying something in could be blocked
Yes.
from recovery
Yes.
because of doing nothing. I mean, it wasn't any surprise at all, was it? The Supreme Court decided as it is, because this isn't smart in line with Press Technic and all those other cases where there's nothing happening at stage one. You look to stage two, don't you?
Yes, I suppose it must have been to some extent a surprise, and that it probably wouldn't have reached the Supreme Court if it was quite that straightforward.
Yeah,
it wasn't.
You're absolutely right. You're probably
I wasn't
simplifying something, but anyway, there we are. Yeah, it was a very different fact pattern.
Yes, but my lady, you're right. It's a Kretz Technic type case where there is no economic activity to begin with, but some
there's no
inputs
stage
purchased.
one.
Yes, exactly, my lady. Exactly. There's no stage one. HMRC were arguing that there was something akin to what we're calling stage one here, but unsuccessfully. That is, for your note, we don't need to turn it up, but page 176 at paragraph 22, that's where HMRC's argument to that effect, my lady, is set out. Please can we pick up the judgment of Lord Hodge. So this is the first volume of the authorities, tab 16. If we could start, please, at page 177. see here, and I won't go through every paragraph of it, it's not necessary, but that there is recognition starting at paragraph 27 that BLP, a management holding company, sold shares in a subsidiary company and sought to recover input tax on VAT which it had paid on invoices, professional services connected to the sale. The share sale was an exempt transaction, and there's a discussion of BLP here. What we don't see anywhere is any part of the decision which says that BLP is wrong if there is a direct and immediate link to the exempt share sale. At 28, first line, it is clear that this ruling in terms relates only to the use of services on exempt transactions. So that's over the page, first line of paragraph 28. Here is the Supreme Court saying BLP continues to be relevant, but only in relation to cases where the exempt supply uses the services. That's our case. That is, you would expect, if that wasn't the case anymore, that the Supreme Court would say, but even where there's use of services in exempt transactions, now the law has moved on. It doesn't say that anywhere. Over the page to page 179, please. I would invite the court to read, I think, paragraphs 31 and 32. Well, perhaps paragraphs 31 to 33. So that is an analysis. So that is an analysis of Abbey National, and at the start of paragraph 33, as you've seen, the Advocate General had essentially contrasted use of inputs in an exempt transaction with use of something which is not a transaction outside the scope. At 33, the CJU in its judgment did not expressly adopt the Advocate General's distinction between the chain-breaking effect of the use of a supply in an initial transaction, which is an exempt transaction, and the absence of that break in an initial transaction outside the scope of VAT. The CJU's reasoning in this case is not only consistent with the Advocate General's approach, but also difficult to reconcile with its reasoning in BLP, unless it was accepting that approach. So we see there recognition by the Supreme Court that the CJU case law, including BLP and Abbey National, recognises that in relation to exempt transactions, if there is use, direct immediate link between that and the input, then there's no recovery. Nothing there to suggest that the Supreme Court sees that as having changed. Next, there is the description of Kretz-Technik. On page, paragraph 38 at page 182. Perhaps I could just invite that to be, well, perhaps 37 and 38. We see at 34, this is all about Kretz-Technik. And if I could invite the court just to read 37 and 38, please. I take the court to that passage, not because it says anything that may on its face seem terribly surprising, controversial, but because paragraph 38 is cited by the first tier in this case as part of its rationale for why it says there is a modification in fundraising cases of the test of direct immediate link. And that's to misunderstand paragraph 38, which is simply talking about the facts of Kretz-Technik, where there is a share issue, not a share sale, so an outside the scope activity or transaction, rather than an exempt sale of shares, which use the inputs. It's simply reiterating that in those circumstances, there can be a direct immediate link with downstream activity. Page 184, please. Invite the tribunal please to read paragraphs 41 down to the end of 43, and also Roman numeral 4, which is a subparagraph of 44. So what we see here is our understanding of what has moved on since BLP. 41, the CJU has called into question its ruling in BLP in the light of its developing jurisprudence attributing input expenditure on the raising of capital to the general overheads of an undertaking. We then see the facts of SKF set out. 42, we see the Advocate General and that paragraph which I took the court to earlier, paragraph 89.3, which is the very sweeping paragraph about attribution of input to an exempt transaction. And 43 tells us what has to be done and the extent to which the CJU differed from what the Advocate General said. Disagreed with his conclusion in relation to an exempt transaction involving a sale of shares in circumstances which were analogous to the facts of this case. And I pause there. That's not saying everything, that's saying...
That's a difficult phrase, isn't it?
I understand it. The only way I can make sense of it is that it means where there isn't a direct and immediate link to an initial supply for consideration in the course of economic activity. I think that's what's analogous to the facts of the case. If those are the circumstances, then it follows the inputs can be overheads. And held that there was a right to deduct input VAT paid on services acquired for the purposes of a disposal of shares if there is a direct and immediate link between the costs associated with the input services and the overall economic activities of the taxable person. So not there automatically is, which is, if I understand it, is the first position, just if there is on conventional principles that direct and immediate link with downstream activity. It held that the referring court should take into account all the circumstances surrounding the transactions to determine whether the costs incurred were likely to be incorporated in the price of the shares sold, or whether they were only among the cost components of transactions within the scope of the taxable person's economic activities. So there we see, plain as day, the need for the two-stage test, and nothing about modifying what constitutes a direct and immediate link in relation to a specific economic supply. And at 44 we get a summary of reasoning, and I refer the court to Roman numeral 4. On the other hand, where the taxable person acquires goods or services and uses them for the purposes of transactions which are exempt or do not fall within the scope of VAT, no output tax can be collected or input tax deducted. So we see there the Supreme Court, we say understanding SKF as the commissioners do, of not changing a great deal, but saying there must be a factual analysis where there are competing arguments as to whether the specific or the downstream is where the immediate link lies. And not saying anything about a modified test. Could I invite the court please to read 46 and 47? So at 46, we see that as essentially a summary of our analysis of the fiscal neutrality problem that was to be solved, or that the court had a particular concern about in SKF. The objectively similar transactions that shouldn't be treated differently for tax purposes were the taxable downstream general business activities. if they use the inputs. And at the end of paragraph 46, we see the Supreme Court understand that the CJU accepts the reasoning of the Advocate General, but includes some sort of modification.
Can I just quickly unpack that? So is that, when it talks about the distinction which AG Jacobs drew, is that the chain breaking thing? That's to do with exempt, stage 1 exempt, and taxable, possibly after that. So it's the chain breaking effect of an exempt transaction.
Yes,
really
exactly, yes.
Then these words, but recognise the need to modify the result of that an exempt initial transaction in order to avoid discriminatory fiscal treatment.
Yes. And that modification is, well,
It's limited to something at stage 2. In other words, where there is no direct and immediate link to the transaction.
Exactly. So it's modified the very blanket approach of the Advocate General to say there is the need to engage in that 2-stage process, stopping at stage 1 if you found direct and immediate link with a specific exempt supply, but moving on to stage 2 if you have not found that on the facts. I'm sorry that 47 isn't marked in the margin, but it struck me, I'm afraid, only after the bundle was completed that it was very important, because 47 addresses paragraph 59 of SKF, which you will recall says use in an exempt transaction means that there is no recovery of the input tax on the input. And here we see, towards the bottom of the page, on the right-hand side, page 185, to make sense of what that means, in order to be consistent with the CJU's reasoning outlined above, that statement, when applied in the context of a fundraising transaction such as the sale of shares, must be a reference to the downstream transactions of which the input costs form a cost component, and not the initial fundraising transaction, unless the cost of the inputs was a component of the price of the shares in the initial transaction. So I understand that sentence to be making sense of why is the court referring, the CJU referring to use in an exempt transaction, blocking input tax recovery, and the Supreme Court is saying here, well, in the context of fundraising, that must be saying if the downstream activity is exempt, there's no recovery, if that's where the direct and immediate link lies. But the words after the comma right at the end, unless the cost of the input was a component of the price of the shares in the initial transaction, means that if that is where the direct and immediate link lies, then the ordinary rules for an exempt transaction apply, and there's no recovery. Because otherwise, those words probably wouldn't be there, or the court would be saying, and that's also true, even if there is use in an initial exempt share sale, because that's no longer the end of the question. And the Supreme Court is saying the opposite. Now, I've never...
Sorry, so just to make a note of it, so you say the court couldn't have said what it said at 47 if
yes.
Mr. Firth's right in his arguments, because they would have had to explain it, they would have had to say something different at 47.
Yes, it would. And at 59, the CJU in SKF would have had to have said, actually, this general rule about exemption is only a general rule, and in fundraising there is something different to be done. And so far as I can recall, Mr. Firth has never explained what this paragraph means, because it's recognising the ordinary rule, the only rule where there is use in an exempt transaction, and it's saying, well, it's probably talking in a fundraising context about downstream exempt activity, but that rule also applies if it's talking about specific transactions. I can't read it any other way, and I've never can't recall Mr. Firth ever having any explanation for what that passage is saying. Paragraph 49, please could the court read that on the same page, well, on page 186. So that is, again, we say the Supreme Court, admittedly in a case that's not about exempt transactions, agreeing with our analysis of SKF and what it says about exempt transactions. Here we see the Supreme Court saying that what needs to be done to avoid discriminatory treatment is to engage in that two-stage analysis. And although it doesn't say if the finding is that the input is directly immediately linked to the exempt transaction, it must be that the conclusion, see paragraph 47 above, is that there is no recovery. Otherwise, why would you engage in that two-stage process? If Mr. Firth was right, there would be no need to inquire into whether the exempt transaction uses the inputs, because it wouldn't matter. And here's the Supreme Court saying quite the opposite.
So the phrase, the costs associated, blah, 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 are incorporated in the price of the share sold in the initial transaction. That's another way of saying there's a direct and immediate link.
Correct, my lady. Yes. Used interchangeably and used without any suggestion of some new, modified, narrowed, restricted test, contrary to what the tribunals in this case have in fact applied. Page 189, please. Perhaps just for later reading, but paragraphs 57 and 60 seem to us to include further analysis suggesting essentially our case, and importantly at page 191 you see a summary of case law at paragraph 65, and the tribunals, and Mr. Firth place great emphasis on this passage. It's important to note at the outset, it begins with, I derive the following propositions which are relevant to this appeal from the case law. And I emphasise that because what's said after doesn't include very much description of what happens where we have an exempt specific transaction as the initial transaction. And that's unsurprising because the Supreme Court was not dealing with that. Paragraphs Roman numerals 2 and 3 are effectively saying you need a direct and immediate link between the inputs and a taxable supply, either a specific one, so that's Roman numeral 2, or Roman numeral 3, alternatively, the general taxable downstream activity. Please could the court read Roman numeral 4 right at the bottom of the page and over the page. So this is a paragraph which great emphasis has been placed on. The first part of the passage tells us that where there is whether a professional service is required for an outside the scope fundraising transaction, then use in that transaction doesn't prevent potentially there being a direct and immediate link to downstream activity. And right at the end, the same may apply if an analogous transaction involving the sale of shares is classified as an exempt transaction, reference SKF paragraph 68. So that doesn't tell us very much. It does tell us that the same does not automatically apply. may apply indicates clearly there are circumstances where it will and circumstances where it won't. And the Supreme Court is going no further than to say there must be the same tax treatment if we're in the circumstances of SKF paragraph 68, which I've already taken the court to, and which only applies if the direct and immediate link is solely, it only can be solely, with the downstream taxable activity and not with a specific exempt supply. So the only other part of the decision that strikes us as of any particular relevance is right at the bottom of page 193 to 194, where we see paragraph 70, and Lord Hodge specifically talks about what's being modified after BLP. Essentially, this paragraph is a recognition that there will need to be evidential inquiries looking at objective evidence to support the direct and immediate link between an input in a fundraising case and proposed economic activity down the line. And right at the end, almost right at the end, 5 lines from the end, this may involve HMRC in more investigations than the CJU envisaged in BLP paragraph 24, but it goes on to say that that can be achieved. So BLP is not stated too long in relation to what it says about exempt transactions, nor is it bad law, nor is it superseded. It is stated to be modified only to this extent. So in circumstances where there is no exempt transaction using the input, i.e. past stage 1, or on the facts of Frank Smart, there never was such a supply that could use the input. Yes, Mr. Firth is right that HMRC argued that use in something that wasn't a supply could prevent recovery and failed. But that is, obviously we accept that we were wrong to that extent. But in this case, what we have is use in an exempt transaction found as a matter of fact, found that they were all part of the process of selling the shares, the inputs, and the Supreme Court, to the extent that it comments at all, very much to our mind is agreeing with our analysis. Fiscal neutrality problem is at stage 2. Costs relating to, but not directly immediately linked with an exempt share sale won't prevent the recovery at stage 2 if the requisite evidence is there to prove the direct and immediate link with the general downstream activity. Just before the break at lunch, if I could take Tribunal, please, to tab 19, which should be in the same hard copy volume. And pick up at page 220. This is the Court of Appeal's decision in Royal Opera House, 2021, relatively recent. Royal Opera House, of course, ran an opera house, and it claimed the input tax incurred on production costs on the basis that it argued there was a direct and immediate link, not just to the ticket sales, which were an exempt supply, but also to taxable supplies of catering. Page 220, we see there at 16 that the court sets out Article 168, the direct and immediate link test, as it appears in Principal Black Directive. And at 17, the reference to cost, this is page 220, the reference to cost components in Article 1 might suggest that the cost of the goods or services supplied to the taxable person must be reflected in the price charged for the relevant output supplies made by the taxable person. That is not, however, the case. As Article 168 makes clear, it is the fact that the goods or services supplied to the taxable person are used for the purposes of the tax supplies made by the taxable person that gives rise to the right of deduction. It goes on to say there must be an objective ascertain of that. 18. Cost components and objectively determined purposes are very general terms whose meaning may not be clear when applied to actual supplies. By its decisions, the CJU has established that for an input supply to be made for the purposes of an output supply, there must be a direct immediate link between them, as confirmed by the reference to cost components, then cites a variety of cases, including BLP and Franke Smart.
You can see Article 1.2, which uses the term cost component, set out at paragraph 15.
Yes.
VAT is chargeable after deduction of the amount of VAT borne directly by the various cost components.
Yes.
So it is there in the current directive.
And over the page at 19, it has further been accepted that where the direct immediate link is not with a particular supply by the trader, but with the whole of economic activity, in other words, it is an overhead, the input tax and the supply to the taxable person is deductible from the output tax, etc. So what we see there is straightforward rejection of cost components, meaning that the price of the input needs to be reflected in the price, and a recitation of the it's one or the other direct and immediate link to specific or general. Can't be an overhead if there's use in a specific supply. Page 228, please. As Lord Hodge said in Franke Smart at 28, it is clear that the ruling in BLP relates, present tense, relates only to the use of services on exempt transactions. In contrast to the facts of that case, the CJU gave the example of professional services provided for the purpose of taking out a bank loan to meet liabilities incurred in the course of its taxable activities. Such services would not have been directly and immediately linked to an exempt transaction, and the costs of such services would have formed part of the taxable person's overheads. That's just an underscoring of the fact that BLP is still relevant in relation to exempt transactions. It's still good law. Page 234.
But isn't David Richards, or just David Richards, taking both? It's the point made in BLP. It's a very firm confirmation of BLP, because that's exactly the point that was made in BLP. If the taxpayer had done it by way of loan, the outcome would have been different.
Which must still be true.
It's just
yes.
Still true.
It must still be true, my lady, because fiscal neutrality doesn't knock down the walls between categories which the legislation says must receive different treatment. They are not similar supplies. Yes. Paragraph 234, please, which is, sorry, page 234. And this is the court considering the Sveda case. The use of phrases in Sveda focusing on an economic link on which the Royal Opera House relies do no more than explain the nature of the connection required to satisfy the test of a direct and immediate link in cases where there is also...
Sorry, I lost you.
So sorry, my lady. Page 234.
I was on 234. That's discussion.
Paragraph 83.
Right at the bottom
Got
of
it.
paragraph
Thank you.
83.
Michael. Yeah.
The use of the phrases in Sveda focusing on an economic link on which the Royal Opera House relies do no more than explain the nature of the connection required to satisfy the test of a direct and immediate link in cases where there is also a link with non-economic activities, such as the gratuitous provision of the path and of the retail vouchers. They do not herald a new and broader test for determining the existence of a direct and immediate link, as is made clear in the Advocate General's opinion and the CJU's judgment in Sveda and in Rochester Patton's judgment in Associated Newspapers. The legal developments after BLP related to the recognition that overhead costs, which could not be linked to specific transactions, could be linked to the output transactions of the taxable person's general economic activity. That is our analysis. That is what has evolved since BLP, not the treatment of directly and immediately linked inputs to exempt supplies. Same page at 89. At J, halfway down the paragraph, sorry, not the same page, page 235, over the page, at 89. At J, halfway down the paragraph, however, the provision of the path was, this is in Sveda, viewed in isolation, a non-economic activity, so could be disregarded. with the result that there was, for VAT purposes, a direct and immediate link between the taxable supplies and the chain of the supply was not severed. So I just bring the court to that to emphasise that it is the non-economic activity using the input which meant that it was possible to look through it, disregard it, ignore it, whatever word we use, and ask the question, is there a direct and immediate link to the input? Whereas here the tribunals have looked at the specific supply, there's a finding of fact that the inputs were used in it, that they were all part of the process of selling the shares, and yet there has still been a finding of a direct and immediate link to the general economic activity which was taxable. And what the Court of Appeal is pointing out here is it's that special feature of a non-economic activity, the provision of the path for no consideration, which meant that it was possible for the inputs to be overheads.
So you're saying in a way that the tribunals here did what the referring court did in SKF?
Yes.
Made the same mistake?
Exactly, yes. And our argument has been the same all along. For instance, paragraph 71 of SKF says that's not the approach, but thus far, in our view, that hasn't landed for reasons we don't really follow, but neither tribunal has understood that in relation to overheads, we can now look at ultimate economic purpose. But you can only have an overhead if there's no use in a specific exempt transaction. I'm at time, and I am very much on track and nearly finished my submissions in relation to the main bill. It may be now is a sensible time.
I think now's a convenient moment, yes. We'll say 2 o'clock.
All rise in favor.